Okay, we are uh, beginning the second case on our morning session. Welcome to both of you. This case is 119222 in the matter of the equalization appeal of Target Corporation. I am Chief Judge Karen Arnoldberger of the Court of Appeals. To my right is Judge Henry Green, who is the longest serving member of our court, hearkening from Leavenworth, Kansas, and he has been on our court for 28 years. To the Judge Boozer, that's unbelievable to him.
I just think it may be time for him to go, but we'll take that up later.
Okay, and also on the call or on the panel today is Judge Michael B. Boozer. He has been on our court for 16 years and is from, at least most recently, from Johnson County. We usually do not want the parties to spend time going over the facts. But because we're on this YouTube environment now, I will allow the appellant about 2 minutes to just give a very quick summary of the facts to kind of set the stage. And I won't count that against your time. So if the parties, I've called the case, if the parties would please state their appearances.
Thank you, Judge Arnoldberger. The Board of Commissioners of Johnson County, Kansas appear by and through Brian Carpenter, Assistant County Counselor.
Please the court, Your Honor, and good morning, Mr. Carpenter. The Target Corporation, Dayton Hudson Corporation, and 8th Street Development Company appear by and through Counsel of Record R. Scott Beeler of Lathrop GPM.
Okay, and Mr. Carpenter, did you wish to reserve any time for rebuttal?
May it please the court, Judge Arnoldberger, the county would respectfully request to reserve 3 minutes of its time.
3 minutes, okay. We're ready to start whenever you are, and like I said, I'll give you a couple minutes just to do a quick overview of the case before I start your 15 minutes or your 12 minutes.
Thank you, Your Honor. The facts are pretty important in this case, actually, and this case is before the court on remand from the Supreme Court. Solely the issue today is whether the Board of Tax Appeals acted properly in failing to issue a full and complete opinion. And facts in this case that are germane for those watching are that on February 20th, 2018, the Board of Tax Appeals issued a summary decision. That on February 26, 2018, the appellee taxpayer requested a full and complete opinion of tax appeals. On March 27th, the taxpayer dismissed its request for a full and complete opinion at the Board of Tax Appeals. On March 28, 2018, the county filed a petition for reconsideration in objection of the motion to withdraw the taxpayer's request for a full and complete opinion. The case went to the Court of Appeals, where the Court of Appeals essentially determined it was not ripe for review. Appellant petitioned to the Supreme Court, and the Supreme Court remanded it to you, which is why we are here today, Your Honor. And I hope I got that wrapped up in 2 minutes and can now start the 12.
Yes, I think that's fine. The issue basically is by not issuing a formal opinion, that cut off the right of the county to appeal, because there must be a formal opinion before an appeal can take place, and that time had passed. So the issue is, was the board right to not issue a formal opinion under these circumstances? Okay, you can go ahead, Mr. Carpenter.
And thank you.
But before you do, could you refresh our recollection as to what was the value of the Target property that was assessed by Johnson County originally that got this thing started? I'm looking just for a ballpark figure here.
Your Honor, I believe, and to be quite honest, I did not anticipate that question simply from the procedural standpoint. Right. I believe they were around 18 million, but
okay.
I can look it up. But
all right, no, that's fine. curious as to what is your best recollection as to what Target felt the appropriate valuation was.
I want to say in the ballpark of 9 to 10 million. Again, I'm trying to go from the best of my recollection.
Understood. And the best of your recollection on what Boda said was the appropriate valuation.
I think closer to the taxpayers, but not exactly the taxpayers, Judge Boozer.
Okay.
Did I pronounce that right? Is it Boozer?
Yeah.
Or, okay.
Boozer's
Judge Boozer.
fine. Yeah.
I apologize.
We call him lots of things, but
You can, I cannot.
So Boda came up with a figure that was a little higher than Target's evaluation, but considerably lower than what the county assessed about the property as.
Again, I believe, to the best of my recollection, Your Honor, that was the case. I
All right,
certainly don't want to deceive in any way, but I'm going on my recollection and did not look at that specific issue prior.
Okay.
Because why I didn't is because the merits of the case were not before you on the remand. It was solely the issue of whether the board improperly acted when it failed to or refused to issue a full and complete opinion. So I apologize, Judge Boozer.
Go ahead.
All right. From the county's perspective, this is a fairly straightforward case. The clear and ambiguous language of KSA 742426, which governs the appeal from the Board of Tax Appeals, is pretty straightforward. In 742426A, the statute says that any aggrieved party within 14 days of receiving the board's decision may request a full and complete opinion be issued by the board in which the board explains its decision. Except as provided in subsection C4, this full opinion shall, adding the emphasis, shall be served by the board within 90 days of being requested. Now, the C4 reference is important because in that same statute, C4C states that only way voter relinquishes its jurisdiction is if taxpayer requests district court review pursuant to C4B. That did not happen in this case. Moreover, the language is silent when it comes to unilateral dismissals of the case. And the county can only appeal to the Kansas Court of Appeals, and it can only appeal upon a full and complete decision. Therefore, it leads to an absurd result because that allows the taxpayer to, in essence, control the county's litigation. And it's important to note that both parties can be aggrieved. And that comes to your prior question, Judge Boozer. Certainly, there are times when neither side gets what it wants. So any aggrieved party, both can be aggrieved parties, and that full and complete request is a triggering mechanism upon which the board cannot optionally determine to not issue a full and complete opinion. The board itself issued administrative regs, and they say that if there is no specific statute governing dismissals, then the Kansas Code of Civil Procedure, if there is no specific procedural regulation that covers it, then the court goes back to the Kansas Code of Civil Procedure. And if that's the case, and the Kansas Code of Civil Procedure is applicable here, then the county had become fully invested in the litigation. You had 6 days of testimony, you had experts, you had post-trial briefs, you had a continuance requested by the taxpayer, you had a voluminous record. At that point, it's the county's position that the only way that this matter could be dismissed is upon mutual agreement of the parties. And it would not have been inappropriate for BOTA to reject the taxpayer's motion to dismiss its request for a full full and complete
Mr.
opinion.
Carpenter, is
that
it
time.
common practice that if one side requests a full and complete opinion, that the other side relies on that? Or it seems like if we were to go along with the district court on this, it seems like the lesson would be, if you want a full and complete hearing, you better, or opinion, you better file regardless of which side you're on.
There are times where both sides file a request for a full and complete, but the county relied on the clear, unambiguous language that once that triggering event happened, that the Board of Tax Appeals was obligated to issue its full and complete opinion. And the county even mentioned in its briefing that absent that, again, we rely on the language being clear and unambiguous in 74, 24, 26, saying that the only time that the board relinquishes its jurisdiction is if the taxpayer appeals to district court once the full and complete has been filed. But the county would believe that its objection and motion to reconsider that were denied by the board would leave time for the county to file a request for full and complete. And what's important in that is that the board, in its denial of the county's motion, stated that the county could not cite to any statutory authority or basis for the board not to accept it. The county believes that was somewhat backward logic because the board itself is the creation of statute as set forth in the county's brief, and it is only empowered and allowed to do what it is statutorily granted to do. It is not statutorily granted the opportunity to dismiss and absolve itself of issuing a full and complete opinion absent that matter being appealed to district court.
Did Johnson County, in seeking a reconsideration, did they provide any reason why they did not appeal or ask for, rather, a full and complete opinion like Target did?
And I will go back. I don't think it was articulated, Your Honor, but I will go back to the county didn't believe it had to at that point because someone had already done it, triggering the statutory obligation of BOTA to issue its full and complete opinion.
So we don't have, as far as you know, we don't have anything in the record that would indicate why Johnson County didn't seek a full and complete opinion before the deadline ran.
We would not have anything in the record. My discussions indicate that we rested on the clear and unambiguous language of the statute in our belief that it was not necessary.
All right.
And the clear and unambiguous language that does not allow the board itself to accept dismissals, unilateral dismissals.
If we could set aside the statutory language for a minute, there's also the issue that maybe what Target did was legal, and maybe what you're complaining about is legal, and everybody had a statutory right to argue these issues in front of BOTA, and BOTA made a decision. And one of the things that you've alleged, Johnson County has alleged, is that that decision was arbitrary, capricious, or unreasonable. So my question is, set aside your statutory arguments, give me your best argument as to why BOTA's decision not to allow, or to allow Target to withdraw their request, or not to allow you to ask for a full opinion, why that was arbitrary, capricious, or unreasonable.
It's arbitrary, capricious, and unreasonable because by failing to issue a full and complete opinion, the board itself granted control over the county's appellate rights to the opposing party. That is arbitrary, capricious, and unreasonable, and leads to an absurd result. It forestalls the ability to pursue a merits-based claim because we don't have a full and complete opinion, which is the only way that the county can pursue a merits-based claim.
But to just push back on that, wouldn't part of BOTA's consideration be, well, Johnson County, the ball was in your court. All you had to do was ask for a full opinion, and you could have gotten one. So the reason we're making this decision is you had your chance and you didn't take it, and therefore we're going to say that the best argument is done by Target.
To get, with all due respect, Your Honor, to get there, BOTA had to go outside and exercise powers that it is not statutorily allowed to do. And State v. Trickett, as cited to in county's brief, is explicit on that. They are only empowered to do what they are empowered to do by statute. They cannot reach out. They're not vested with any other powers because of their creation of statute. So if that is BOTA's reasoning, that becomes arbitrary and capricious because they are exercising powers they don't have and allowing an adverse party to control the appellate rights of the opposing party, which is arbitrary and capricious and unreasonable. From the county's
Mr. Carpenter, I
perspective.
don't remember from the file here, but did when Target asked to withdraw their request, was that something that the county was noticed up on, or was there a hearing, or did the BOTA just grant it?
The Supreme Court decision points to that, Judge Arnold Berger. It specifically cites that taxpayer counsel with BOTA counsel and finding that it was the only one that had requested a full and complete opinion, dismissed it. So they would have copied the county counsel. And what's important is they did copy county counsel on it because county counsel, my predecessor, filed the county's response immediately the next day.
Okay, so they file a motion to withdraw it. The county files a response, and then what?
And then BOTA makes a determination that the county
Okay.
could not cite any specific statutory authority as to why the taxpayer did not have the right to dismiss. And that's
it
where the
was
county,
made clear in that response by the county, I'm assuming, that the decision by BOTA would result in the county losing any appellate right. Any right?
I believe so, Your Honor.
Okay, thank you. You are into your rebuttal time, so
Okay, I apologize.
no, nothing to apologize about. I should have notified you a little bit earlier, but I'll give you your full 3 minutes, but you're done with your first part. So unless there are any other questions from the panel at this point for Mr. Carpenter. Okay, Mr. Beeler, you've got 15 minutes.
Thank you, Chief Judge. Judge Boozer, to your question earlier, there were a multitude of Target properties. As the court's probably aware, there are multiple stores throughout Johnson County that were subject to appeal. But by example, the very first of those stores, the county initially valued it at $21 million. They subsequently, on their own volition, I suppose after knowing some of the evidence, but they reduced their number to 17.8 million. The taxpayers' appraised value submitted at evidentiary hearing was 7 million, and these are rounded numbers, of course. And BOTA ultimately ruled 12 million on that site. That is representative of all of them as to how it worked out. And it is the reason that Target sought the full and complete opinion was, one, the statute requires a very short time period to do that, 14 days. And it is applicable to both sides. And to the court's question of Mr. Carpenter about whether that typically is one party or both parties, it is, to my experience, this is the only case I've ever seen where, or Ms. Terrell, who's widely experienced in this and was involved directly in these filings, has ever seen, where only one filed it, where they were then subsequently going to say they had some sort of appellate rights. That's because the county and Target and other experienced taxpayers know that in order to proceed to the next level, you have to have the full and complete opinion. And only the taxpayer can go off of the summary. And when they do that, it's an appeal to the district court, not to complicate this because that wasn't elected. But
Wasn't this, Mr. Beeler, wasn't this a gotcha?
absolutely
you
not.
call the board, you find out they haven't filed, you know their time is run. It's like, gotcha. We're gonna.
Well, it's not. You have to go back first of all and understand that you're talking about corporate entities here, with corporate offices and staff to be consulted and determinations to be made as it works its way up the ladder. The appellate or the request for the full and complete opinion was filed to preserve it, which is what any party should do. That's what Target did. And then they went through that process. And as we cite in our briefing, ultimately they decided there were reasons not to move forward. That from a cost standpoint, a comparative standpoint, et cetera, they decided that they could live with BOTA's determination. Now, time-wise, did it happen after the time period had occurred? Yes, it did. And was a phone call made to make sure that the time periods were understood and agreed and what had been filed so the client could make a full decision, meaning based upon all the facts that could be known? Yes. And it was after the date. But that's not, again, that's not the fault of Target. What we have here on page 7 of the county's own brief, this is a quote, BOTA's action essentially provided the taxpayer an opportunity to eliminate the county's right of appeal of this matter. That statement is incorrect. What caused the county to lose its right of appeal was its own failure to adhere to a mandated prerequisite to appeal. That is, protect your rights, as the court indicated earlier, by filing the appropriate request.
Okay, Mr. Beeler,
Mr. Beeler.
would you ask, or I'm sorry, would you answer this for me?
Sure.
Give me your best argument as to why, if BOTA realized that by not issuing this opinion that they had said that had been requested, that it was going to cut off the county's appellate rights. Give me your best argument as to why that wasn't an abuse of discretion, why that was unreasonable.
Well, first of all, it would cause me to ignore statutory prerequisites, which again are that each party desiring to preserve a right of appeal must file the appropriate filing. In this case, the request for a full and complete opinion. As I will get to, civil procedure or otherwise is fraught with instances where motions can be filed, requests for medical, motions for continuance, motion for summary judgment, motion, request. They can all be withdrawn. The only ones that cannot be withdrawn are when it's statutorily prohibited from withdrawal. That didn't occur. In my opinion, it might have been, and likely would have been, arbitrary and capricious had they not allowed it, because the county failed in its prerequisite, its mandatory prerequisite. So we start and end with that. The county spends a lot of time looking at, speaking of civil procedures, 641A, which of course talks about when a party can or cannot voluntarily withdraw or dismiss a case. Mr. Carpenter's addressed it this morning and said this case was all worked up. It was this, it was that. I don't dispute any of that. But the fact is, not only was it worked up, it was tried. The evidence was presented. The BOTA found the county failed in its burden of proof and adopted these other alternative numbers. At that point, the case wasn't subject to dismissal. It was over. The only way its case life could be extended was the filing of a timely request by the county for a full and complete opinion. Without that, as Mr. Carpenter indicated, Your Honor, the county was without any right of appeal. That's my point. As soon as the taxpayer, looking at its own case to protect its own appeal, decided to withdraw, there was no longer a pending request. ABOTA had no jurisdiction ever to extend that time and say, okay, go ahead now. I might add, Your Honor, not only did the county fail to ever file that request within 14 days, but once, if you will, all of this hit the proverbial fan, they didn't file anything to say, can we do it out of time? They never filed a request for a full and complete opinion. They also,
Mr. Mueller?
Yes, sir.
Could I ask you, would you agree with me that there is no statutory language that would necessarily permit Target, in this case, to withdraw a request for a full opinion?
I would have to agree that there is no black and white statutory language to address withdrawal, but tagged to that, as I indicated earlier, Your Honor, there isn't in virtually any statute unless the withdrawal is prohibited. It is a presumed discretionary factor.
Let me follow up then and say there doesn't seem to be much precedent in this area. Are you aware of any other instance where the board has allowed, or let me ask it this way, are you aware of any instance where a party who has asked for a full opinion withdrew it, and or what ABOTA did in that circumstance?
I am aware, Your Honor, that requests for full opinions, appeals, whether we're talking about BOTA or under the Code of Civil Procedure in our district or appellate courts, it happens every day.
I'm limiting my question to BOTA as far as a request for a full opinion. Are you aware of any other instance where a party who has originally requested it withdrew it?
Yes. Historically, yes. I can't say that there's a citation, but from experience and practice, yes. And that does happen. And I don't mean to get away from your question. I hope I've answered it. But to Mr. Carpenter's point earlier about what is an absurd result, Your Honor, picture this. You're to accept the county's position of somehow 24/74/24/26 is a mandate to BOTA that they have no choice about. What if the case settled? What if the parties simply said, we all agreed to this $12 million? According to the county, BOTA would be mandated without any ability to do anything else to spend the taxpayers' time, trouble, and money to come up with a full and complete opinion that was absolutely meaningless. That is what I'm talking about. If we look at appeals, as I said, the new life of a case, if Target filed, or I, in a personal case, filed an appeal because I didn't necessarily, I'm the plaintiff, I won, but I didn't, to the prior case I was listening in on, court's question about actual damages. I don't like the amount of the award. I have a right of appeal. But the other side, who lost the case, kind of likes that number, they don't cross appeal. Are we really saying what would happen down the road then if I, as that plaintiff, decided I didn't wish to pursue my rights of appeal any longer? I moved to withdraw my appeal. And the other side says, well, gosh, I was relying on that appeal. Now I want to cross appeal. Well, I think we all know the answers to how the court would deal with that. That's exactly what the county is asking for here. They are saying, we recognize we did not do what we were mandatorily required to do as a prerequisite to even having appellate rights. They say that we removed their control of their appeal. No, we didn't. They never had a right of appeal unless the taxpayer who controlled, because they filed, and I would say this, the party who files to have control continues to have control until they don't. The taxpayer had that right to withdraw that appeal. The county had nothing to say about it, and certainly has cited no rule, no law that says a withdrawal is prohibited. Moreover, they've cited no rule, no law that says they had the right to rely on the filing of an independent party in order to preserve their own rights, especially when there is a statutory protocol and a mandate as to how they can and could have and should have protected their rights had they wished to do so. And I add to that at the end, even after the milk was spilt on the table, they didn't move to do that. They've only
Mr.
come at the very end of the day.
Okay, Mr. Beeler, I have two questions for you. First, is it your position that you needed the board's approval to withdraw your request? Do you have a position on whether or not you were required to file a motion with the board in order to withdraw your request?
Well, I believe procedurally, Your Honor, the answer would be yes. Again, just as I would if I had an appeal directly in your court. I think in order to solve that matter, I needed to file it, but I believe it was administrative for all practical purposes at that time. It was our right.
You analogize this to motions happening all the, people are filing motions all the time.
Sure.
Is it your position that whenever you withdraw a motion, you need to seek approval from the court to do that?
I don't know so much its approval as it is notice to the court that we are withdrawing our motion, so that we don't use court assets.
Okay, thank you. And the next question I had,
go ahead.
If yours is a follow-up to what I just asked, go ahead.
Well, it was because, as I understand, you just filed a notice of withdrawal. It wasn't a motion.
That's correct.
Okay.
Right. We just provided notice. We provided notice to the county and notice to the Board of Tax Appeals.
Okay. And my next request is, has Target filed appeals routinely in the past? Has this taxpayer routinely filed appeals from the board's decisions?
I wouldn't say routinely, Your Honor. They have filed other appeals, and in other jurisdictions, there's a reported case out of Sedgwick County.
In Kansas.
Yes, Sedgwick County. Okay. There are other appeals. I wouldn't call it routine. Every year is based upon what the county's appraisal looks like.
Okay.
Appraised value looks like.
Thank you. That was the last of my questions. Any other questions from the panel before? You have about 1 minute. Well,
one of my co-counsel, Ms. Joserand, used, I think, what was a good example in it. There's some movie out there somewhere where the South and the North were in their fight, and you had the one guy on the side of the river who would sing the Southern songs as he pulled the rope to get you over to the other side, and then we get over there, he'd sing the Union songs coming back. But the point is this: if I want to get to the other side of the river, and I'm the county, I want to get to an ability to appeal this $12 million I mentioned, I need to know that I control my ability to get there. I need to have my own boat. I have to file my own request, because if I don't, and I just hire some guy and say, take me to the other side, I rely on him, and he gets halfway there and changes his mind and says, you know what, I don't really want to go anymore over to the other side, I'm going back. That's what happened. If that happens, like the boat, I'm stuck on the side I started. I can't ever get there because I didn't preserve my own rights and abilities. So we ask you at this point, you'd be creating a precedent to where BOTA was required to do meaningless acts if you proceed in this manner. You also would be saying that parties do not need to check the box that is statutory mandates to protect your rights, and that you therefore have the right to rely upon filings of others that may be for completely separate and different reasons that then could change. As I said, a corporate decision, and with that, a withdrawal and a decision not to move forward. That was a decision the taxpayer absolutely had the right to make, and the county was in a position of not having protected the chicken coop, if you will, its backside, if you will, or its appellate rights. And with that,
Mr. Beeler, I do have one more. One more question for you. So you just mentioned the fact that, they had mandatory things they had to do. They shall do certain things.
Right.
What's your best argument about the language of the statute, which says this full opinion that they shall issue an opinion that shall be served within 90 days?
I believe that it's reliant upon the precursor that there is a pending and timely request.
So you think there's
for
a
full
mandatory prerequisite to that?
Absolutely, I do. And so we know through the Supreme Court decision, there was a debate about whether this is jurisdictional. I don't really think it matters. If it's not, I believe it sure could be jurisdictional and that should be dismissed. Or two, if it is not, it is the failure to meet a mandatory precursor to the filing of an appeal.
Okay. Thank you. Any other questions from the panel?
One thing I'd like to comment on the analogy that Mr. Bueller mentioned. I think it was from Josie Wells, outlaw Josie Wells.
I think you're right. I think you're right, Your Honor. I believe you're right.
If you remember Clint Eastwood, when they were singing the Union battle, he cut the rope to the ferry, and the ferry just floated on down the river.
Just floated on down the river. I do. And I love that movie, by the way. And you're right.
Yeah,
it was.
Judge Green knows his Westerns. I can tell you that.
The outlaw
Okay,
Josie Wells.
Mr. Campbell or Mr. Carpenter, I'm sorry, you have 3 minutes in rebuttal.
In response, I'd like to take a high level hit at some of the stuff brought forward by taxpayer.
Yes.
Council argued that each essentially read in statutory language that wasn't there, saying each party needed to make a request for a full and complete. The statute clearly says any party. Once that horse is out of the barn, you can't put it back in. Second, Taxpayers Council referenced that Bodo would have to issue a full and complete opinion if a parties had post-trial agreed to settlement. The settlement would trump because the settlement would have to be filed with Boda. That would be an intervening factor. This is not a notice of appeal situation. Any analogy to that is incorrect. This is a matter that they're obligated to do. Taxpayer would point to the fact that the county did not at any point file a leave to file a motion for full and complete out of time. Boda had dismissed it. There was nothing to do. That's why we filed a petition for reconsideration and a motion for modification. I think this is more analogous.
In your response to the motion, the notice of the motion to, or the notice to withdraw that you got, did you request in that a motion to file out of time, or?
I don't believe so, Your Honor.
Okay.
I'd have to take a look at it. The county believes that another thing to consider is that the county believes this situation is similar to the condemnation statutes in 26-508. And in that case, the Supreme Court has taken a look at that and said that those cannot be unilaterally dismissed by a party. I would cite to Wellington v. Miller 200 Can 651 that in that case, the city of Wellington appealed the condemner's findings and then suggested, no, we'll just dismiss it. The taxpayer or the condemnee objected to that, saying, hey, we're fully vested in it. Once you reopen this, it affects the rights of everyone. This is much the same case in the present. Once any aggrieved party, which is a statutory language, requests a full and complete opinion, both sides are invested. And there is nothing, and it is somewhat a turning of the burden when Boda says that the county cannot point to any statutory language that says they cannot accept the dismissal. That's not the correct way to look at it when Boda's a statutory creation. They need to point to a specific statute that authorizes them to do that. There is no such statute, and the only proper remedy is to remand this case to Boda with instructions to issue a full and complete opinion because they are not released of that obligation. Thank you, Your Honors.
Any final questions for Mr. Carpenter? Okay, thank you both very much. Like the case before you, this has been very well briefed and argued. We appreciate your work on this. We appreciate your answers to our questions. We will take this matter under advisement and get